So how do you go about putting a lien on a person's property? A lien against real estate or even a vehicle is a claim of debt against a person with that asset listed as a leverage or collateral for the lien. For example, the most common type of lien that you probably have heard of is a mortgage. Technically, a mortgage is a lien on a property. But that's not what we're talking about here, is it? We're talking about you leaning against a person for some damages. Put your message below, put some questions below. Let us know what your situation is for getting a lien, and we can address that directly. So if you want to lien somebody's property, it's probably because they owe you money, or they've damaged you, or you feel like they owe you some type of compensation. Maybe there's a debt that isn't paid. Maybe you're a contractor that did work on the property and you want to get that money paid to you. Maybe there's some loss you've incurred because of another party and you want to get reimbursed for that loss. Well, filing of a lien on a property requires a third party to allow you to do it. You can't unilaterally file a lien on a property without authorization. Because if you could, then anybody could just be slapping liens all over the place and people could put liens on your property without proper authorization, and you wouldn't want that to happen. Now remember, we're not attorneys. We're not giving you legal advice. If you have a serious case like this, you want to get good legal advice from an attorney that can advise you properly. You don't want to get legal advice from some guy on the internet. But since we work on cases like this a lot, we can tell you what goes into this type of process. But again, get good legal advice from a qualified attorney. That being said, one of two people need to sign off on the lien. One is the property owner themselves. Now, why would a property owner sign off to give you permission to lien their property? Well, sometimes when you get a mortgage, as an example, the property owner voluntarily gives you a lien for the privilege of getting that mortgage money. Sometimes if you're a contractor, they voluntarily sign off on permission to give a lien if you don't pay them. Your contract will be evidence of authorization to file a lien if they don't pay on the contract. So you may already have signed authorization and not even know it. If you are a party to an agreement that maybe the other person didn't fulfill or didn't pay, in that agreement there might be authorization to file a lien already in existence. If you do not have authorization to file a lien from the property owner, now somebody else has to sign it, because the agency who files liens is the recorder of deeds or the clerk of recorder. Every county does it different, but there's some official government agent that files that lien in the land records against the property. That agent is not going to just take your word for it to file a lien. You don't want them to take your word for it, because if they took your word for it on their property, they could take anybody's word for it to file a lien on your property. So you want it to be a little more complicated than just a verbal whim of, I want to put a lien on a property, because then your property would be at risk too. So who else can sign it? Well, the most common authority to sign it is a judge. And you might think, well, I don't know, court, judge, it's complicated. Well, maybe or maybe not. If you have a valid claim against a person, a judgment or a debt, the court can just sign an authorization of lien and you put it on the property. In fact, if you have a judgment from a court already, a lawsuit judgment, litigation judgment, child support judgment, some other existing litigation, existing court process, you may already have the paperwork you need to file a lien. In many counties, a judgment against a person automatically becomes a lien on any property they own in the county by statute. Again, get legal advice to make sure that you have what you need in your particular scenario in your jurisdiction. If you don't have that type of court paperwork, you may have to go to court to file a hearing to request that a judge signs that lien paper for you to file with the clerk. Are there other third parties that can file a lien? Technically there is. There are some government agencies like the EPA that can file environmental liens. Some Regulatory bodies can lien property as part of their rules and their regulatory procedures. But you want to look at what is the easiest third party that's out there that can authorize you to file that lien. And it depends on why you want the lien. Now, once you get the lien, what can you do with it? Well, the lien filed on the property doesn't magically automatically get you cash in your hand. If somebody owes you $30,000, you file a lien. The minute you file the lien, automatically you don't just magically get $30,000 dropped in your lap. That's not how it works. But what it does give you is some leverage to enforce your lien using that collateral. Some states and counties allow you to actually foreclose on your lien against the property, which means you'd own the property. Some states don't allow that for people who's using it as a primary residence. They want to protect people's where they live, so they don't lose their roof over their head over a civil debt. So you may not be able to do that. Even if you can do it, you have to remember, if there is a first mortgage on that house, which most houses have a mortgage, then you're in second place. You don't get the first priority. You can foreclose on it, but now the house has to get sold, pay off the first mortgage, pay off the fees, and then whatever's left you get. May not be worth it. Where it comes into play is if the person wants to refinance or sell their house, your lien's on there, they have to take care of it before they can transact that sale. What is the mechanics or the procedure of filing a lien? Well, lien normally is one or two pieces of paper that is signed by you and by the judge. It's brought to the courthouse where ownership records of property are kept. Usually the recorder of deeds, clerk of court. Every county is a little bit different. And it's submitted to that clerk. The clerk will review it to make sure that, first of all, it's in a proper format. It's on the right size paper. It's typed up the right way. They'll also look to see if it's functionally accurate. Is it have the right signatures on it? Is it notarized? Is it dated? Does it have a proper legal description? You can't just file a lien on a property that says house that Joe owns. You have to have the legal description of that property. And a legal description you can find in the land records. It's usually a 2 or 3 paragraph text of description of how that land is. Starting at this point, going 200 feet this direction, turning 20 degrees south, such and such. It'll give you a very clear description of the land that is being enforced under that lien. It's not good enough to have an address. 12 Main Street is not good enough to file a lien. You have to have a full legal description on that lien paper. It has to be properly formatted, properly authorized, submitted to the clerk. Once it's submitted, they will put a stamp on it. Received on this date and time. They'll put it in the deed book. Now it becomes an official document. It's a government record. And now you can use that recorded lien to enforce your collection, your recovery from that person. And that's where it can make a big difference for you recovering your money. Some states also allow you to recover the cost of filing the lien, any court cost, filing fees. Sometimes liens also have statutory interest that you can collect, 1% a month, whatever it is. Some states don't allow that. You want to get good legal advice. You may not need an attorney to do the whole thing, but you probably want to get an attorney to at least advise you on what steps to take. You also want to do a good investigation to make sure that you're aware of all the properties a person owns. Just because they live at 12 Main Street, they may own other properties, even in other counties. And that's important, because if they own property in a different county than where your judgment is, that judgment may not automatically attach to those properties. You may have to file a separate lien attachment in those other properties to make your lien valid against parcels that are in a different jurisdiction. So use your judgment, your court order, your debt to your advantage and attach it to a valid lien so that you have the maximum probability of recovering your loss, damage, funds, judgment, whatever it is that's owed to you from that third party. If they own real estate, that real estate isn't going anywhere. You can't hide it like you can cryptocurrency. You can't stash money in a bank account. Real estate is conspicuous and it's immobile. You can't move a property. You can't hide a parcel like you could hide if somebody had, let's say, a piece of equipment you had a lien against. They could hide it in a garage. You can't hide a house. It is where it is. And the land records are public records. Use that to your advantage. Property liens are valuable and helps you get your money.